featuring the industry's top leaders. This is the Executive Edge with Joe McClung.
Hello, everybody, and Floodgate family. Thank you for this edition of Executive Edge. We're bringing out Kevin Zwetch, who is one of the top lawyers in America and have been practicing employment law for over 32 years. And what makes sense is works at one of the best places to work. So he knows employments and how to treat employees. And so, Kevin, thanks so much for joining us. We're here to talk about really all the big changes with non-competes. But before we get into that, I've been lucky enough to get to know you, but the audience hasn't. So tell us a little bit about yourself and Brick Law, of course.
Thank you, Joe, and really pleasure to be here today and to get everyone updated on this new non-compete rule. I'm originally from upstate New York and Rochester, New York, and I became a workplace nerd when I went to Cornell University and graduated from the labor relations school there. And so that's been my focus ever since undergraduate. And I've worked in, before I went to law school, I worked in human resources and employee relations for many years. And then I went back to law school. And so I've been doing this for quite some time now. A lot of my experience in the past was with big law firms, and I've handled a lot of cases across the country. But now I'm really enjoying being a partner at Brick Business Law. And I learned a ton before, and I'm learning a ton now. You know, Brick Business Law provides legal representation across Florida in the courtroom and in the boardroom. And if a business needs to pursue a claim or defend a claim or just get a trusted day-to-day legal advisor, you know, that's what we do at Brick Business Law, and we tend to be hyper-focused, and we want to be, you know, excellent, compassionate attorneys for our clients.
Excellent. That's great. Well, hey, thanks so much for being on here today. I'm going to ask you a few questions, and this is a live event, so if you have questions, comment below because we'll pull some of those up at the end, and Kevin will be able to give us some insight on some of those specifics in there. So make sure you comment below if you have any questions. So for those that don't know why we're actually on, tell us a little bit. What was the FTC's recent non-compete ruling? Give us an explanation. What is it?
Let me kind of unpack that and summarize it. You know, the rule itself was about 5 or 6 pages, and then there was about 600 pages of explanation and justification provided by the FTC. You know, the rule essentially bans all non-compete clauses or agreements across the country, nationwide, and because this is a federal law. And of course, in each state, the restrictive covenant non-compete clause requirements vary from state to state. And right now, they're all going to fall under this federal rule. There's a slight exception for current executives that are under a contract, meaning that if they're under an agreement at the time the rule goes into effect, then those agreements can still be enforced, but you cannot enter into new non-competes with executives after that. And so that's an exception for, and they define the executives that are exempt from that very narrowly. These are policy-making positions, high level, typically C-suite or that type of focus, and a high level of income above $150,000 a year. So this exception is really intended to, you know, focus on just the executives. And that's going to essentially expire at some point because after the rule takes effect, all non-competes will be banned. The only other exception is for the sale of a business, and I'll talk about that a little bit further in the presentation. It also does not, with respect to the scope of this, it doesn't just cover employees, it covers workers, and that's what the rule calls and defines it as workers. Workers is defined very broadly. It includes employees, independent contractors, 1099 folks, sole proprietors, and so there really are no loopholes, you know, as far as the non-compete agreements with respect to individuals are, pretty much no loopholes. Now, workers also includes a person who works for a franchisor or franchisee, but does not include a franchisee that's in a franchisee-franchisor relationship and might have a non-compete.
Interesting. That's
the rules. Go ahead. And the rules requirements also do not apply where a cause of action related to a non-compete clause accrued before the rule's effective date. And what that basically covers is existing actions or existing causes of action that, existing lawsuits or existing claims that could be filed if those claims emerged or accrued prior to the effective date of the law. And now, another broad aspect of the new rule is it very broad, and this is important, and I'll talk about this in some other contexts as I work through the presentation today. But and this is the key aspect of the rule, it very broadly defines what a non-compete clause means. And so a lot of times we go to an agreement and we see, section 12 is a non-compete. That's pretty clear, it's labeled and it says you can't compete. But the definition of a non-compete clause is very broad, and I'm going to read it to you. It's a term or condition of employment that prohibits a worker from or penalizes a worker for or functions to prevent a worker from seeking or accepting work or operating a business. And so again, it's a term or condition of employment that prohibits a worker or penalizes a worker or functions to prevent a worker from getting a job or starting a business. So it's very broad. And the term or condition of employment includes, but it's not limited to, contractual terms, workplace policies, whether written or not. So, the question of whether you have a non-compete clause is one that should be answered. And it may not be as obvious as just in our agreements with non-compete clause, labeled at the top or something. And I'll get to that a little bit more. Mm-hmm. So it's basically, the final point of all this is that non-compete clauses are considered now to be unfair methods of competition by the Federal Trade Commission.
Wow.
And so it's considered, it's unfair method of competition to enter into a non-compete clause, to enforce or attempt to enforce a non-compete clause, or to represent to a worker that they're subject to a non-compete clause.
Wow.
So, that sort of summarizes, the broad reach of the rule and the various components of it and how it's going to affect non-compete agreements going forward.
That is really broad. I mean, just limiting people from being able to work and only exempt sale of a business and executives that are currently under contract and any litigation that's ongoing from previous. But after this takes effect, really that rule, the world of that, really rigid non-competes, I guess we'll talk about more impact, what that means. But and when does this take effect? When does this ruling take effect?
Well, the rule was published April 23rd, I believe, and it takes effect 120 days later, which I calculated as August 22nd. So in August of this year, it'll take effect. There are court cases that one has been filed already, I believe, by the Chamber of Commerce. There are other potential cases that are going to be filed. So there certainly may be legal challenges to this rule.
And would that hold and push the date, do you think, of implementation if all those legal challenges? Is this something, do you see this really being reality in August, or are we talking a year or two until these cases get cleared?
Well, it's hard to say at this point, and it could play out in, somewhat of a, kind of atomized way because of, because in the court system, it might have to go through each circuit court in the federal system. So you could have different rulings in different federal circuits, but it ultimately it could be potentially stayed before it takes place, but we just don't know. But if the rule is stayed, it may not necessarily be stayed nationwide. It could only be stayed, for example, in a circuit court that stays it in that circuit. And so I think it's a little bit unclear as to how it's going to play out. We'll know more as time goes on. But you have to assume that the rule is going to implement in August, and you have to behave accordingly if you're an employer, and you have to, come into compliance, and then see what happens with the court system and how that may affect, the implementation.
Wow.
And those are constitutional challenges that and the very power of the FTC to make this rule in the first place.
Yeah, so that could be something that could be litigated up to the highest level. But for right now, we've got to assume, and if you're making plans, that this August ruling is going to be able to stay until you hear differently, right? This is
Yes.
recommendation. So speaking of that, what do you think? And guys, if you have questions on this topic, I know there's a lot. It has a lot of impact. Please put comment below. We'll pull them up here in a second. But employers, assuming this is going to start in August, what does it mean for them? What should they be thinking and doing as a result?
Well, I mean, it to a large extent, it falls on the employers and the businesses, to comply with this rule. Let me just kind of say a few things. I mean, I think it's a good time for all businesses to examine their restricted covenant agreements and their non-compete clauses, and with both employees and contractors. My own opinion is that it's always a good time to do that, and I always encourage clients and employers to, look at those agreements strategically and manage them strategically as part of the business. So with this kind of a change, this is a good chance to go in there and really, reassess the strategic position that each business is in, and it varies based on the business and what they're doing. It's essentially a business what I call a business protection strategy that every employer should undertake. You want a good agreement to protect the business. If the employee takes a secret formula and wants to, solicit customers or wants to try to compete, you want to be able to take that competing business, and have something pop up there. You want to be able to, have an agreement that you can enforce in court. Practically speaking, the rules should increase competition for talent, especially in industries where non-competition agreements may be more prevalent, or in positions where they may be more prevalent in sales positions, marketing positions, in the medical industry quite a bit. So the practical implication is, you got to look at whether your other clauses, for example, one concern is with a lot of employers have restricted company. Those clauses will still be valid. But there's a couple concerns with those clauses. First of all, if they're very overbroad, then they could be construed to be a non-compete clause. For example, if you have a non-solicitation clause that says you can't solicit any customer of the company no matter what, for a year, new one, heard of them, that could be overbroad.
Well, it looks like our feed got disrupted here a little bit. I think Kevin will be back in a moment here, so when he jumps back on, we'll continue our stream, I believe. In the meantime, what he was saying, if you missed any of that, was really for employers to start really looking at their non-solicitation, because some of that non-solicitation can cover some of their direct concerns, but they're going to need to be something that is not overly broad where it restricts them. It looks like we've got Kevin back. So Anyway, we had our technology did hurt us there. I was trying to recap a little bit what people missed on really that non-solicitation and being able to shore up that portion of the agreement to ensure that it might provide some employers that protection against direct customers that person might be dealing with, but not reach it to a point where it's every customer of the company, which might be considered a true non-compete, right? Would be one aspect, correct?
Correct. And yes, that's true. And then just to make sure that those non-solicit restrictions and trade secret restrictions are actually written in a way that, will protect the company and will be defensible, that you can go in there and use those clauses if you need to. And then, the same thing with individuals on the other side, they want the other person that's restricted by the non-compete or the restrictive covenant, they want to know what's allowed and what's not allowed too, so that they can be in compliance. So it kind of works both ways. But what I see a lot of this evolving toward, though, if you don't have a non-compete, then these other agreements, the other restrictions you can have on solicitation and the trade secrets, they're going to be much more important in terms of being able to protect business information, and also if employees who were previously restricted from going to work for a competitor are now more free to go to work for a competitor, and potentially that might increase the risk that those employees may bring or attempt to bring customer information or trade secret information with them, or to solicit customers now that they're going to a competitor. So having those, clauses, muscular and protecting the business is I think even more important, because you just can't go in and say, this is a non-compete, you can't compete.
Right. That makes total sense. Yeah. Really reviewing that. Now, you mentioned a little bit on the other side, looking as on non-competes. What does it mean for employees? So they're hearing this, they're wondering about their future opportunities. Did it just expand? What should they be doing when considering this FTC ruling and change?
Well, the first thing they should do is they should be expecting to get a notice from their employer or company, that the company is going to comply with the rule and is going to no longer enforce the non-compete agreement. And so they should get that. I think on the employee side or on the worker side, as it's referred to in the rule, it's going to mean, first of all, increased mobility options. And so you may see a lot of more turnover, more mobility, more recruiting efforts, so a lot of that may increase. And there's still a potential risk, though. For example, if you're a business, many people may have heard in Florida, you have like tortious interference with relationships, and those kind of claims come up sometimes in the non-compete context. And those kind of where another employer is allegedly interfering with the other employer's contract, by hiring the non-compete person or soliciting customers. And so those are going to become, much more contested and much more, the focus of things to sort of manage the relationships. And I think, so you're going to see a lot more of that, I think, mobility and people moving between industries. They may face new employment agreements, because a lot of employers may decide to revise or update or tighten up their restrictive covenant agreements. And so they may face, a lot of employers may see new ones. If you're an executive level person, you may have a non-compete agreement presented to you in the next few days or weeks or months, before the rule takes effect, to get in under the window for the exemption for executives.
Question on that, on new agreements, for whether it's non-solicitation or new covenants or having you sign. I've always heard that the enforceability of that is somewhat contingent on the remuneration of that having a contract, to have a reason why they're signing that agreement. Is that an urban legend, or is there some truth to that belief?
Well, I mean, I think it is. There is some truth to that. I mean, and it varies depending on which state you're in and the non-compete restrictive covenant statutes, of the state. But there is some truth to that.
Okay. Yeah. So, make sure, I guess that's another rule to employees, make sure what state you're doing. If you are redoing your agreements, that it is going to be enforceable, and what's necessary for that contract to be considered valid, right? So
Absolutely. And I think, and this has always been the case though, like when you're drafting, non-compete clauses or restrictive covenants, there's a tendency to want to have everything under the sun put in there and be over-inclusive. But that pressure to do that is sort of pushed back on now with this rule because, so you kind of got some tension there. But, in other words, you could give a non-compete agreement to somebody that was a low-level employee. You could never enforce it against them, for example. And this is an odd, but that person thinks, oh my God, I got a non-compete. I can't go out and work, and so a lot of non-compete agreements are potentially used to sort of create pressure points. And I think there's a greater risk of doing that now because the other clauses that you need, the solicitation and the trade secret protections, they need to they need to be robust and enforceable. And you don't want a judge saying, no, I'm not going to enforce that clause for you. And so, when you need it to be enforced.
Yeah, that makes sense. It makes sense. That's some good suggestions, and for employees to go back and look at how is their agreement written? What is that? Look at those other clauses as they're considering, can I now move or not? What does that mean? And looking at those clauses as currently written, or might be a new agreement coming to be more what those do, because they're going to have a greater impact. That now the non-compete section is, as we see it now after August, not going to be a meaningful portion of the agreement.
Yes, and I think that seems to be the case unless we hear from further developments, and I think we will be hearing more from the courts and as this progresses here over the next few months, and it'll be interesting to see how it all plays out. But it's certainly a dynamic change in the non-compete environment nationally, and something that every business has to come to grips with and figure out pretty quickly.
Good. Well, no, it's a big change. So, Kevin, thank you for coming on, giving our time. If there's any questions, I didn't see any pop up, but if anyone has any questions for Kevin about this this ruling, this impact by the FTC in regards to non-competes, please post it below. Obviously, we'll be monitoring this feed, so if there's things that pop up, let us know. And of course, if you want some guidance, some expertise from one of the best law firms in Florida and one of the top lawyers in America, reach out to Kevin, because I'm sure he can give you some guidance no matter what state you're in, and being able to support you on what this means for you as a worker, I guess was the term that was used in the agreement, and an employer, so you can make the right path for your business and career. So doesn't look like we have any questions here, Kevin, or everyone's just trying to digest this big change, I'm guessing.
Yes.
But I do appreciate your time. Thank you for giving us some very meaningful insight and understanding of this major change in employment law.
Thank you, Joe. I really appreciate the opportunity to be on this broadcast and to cover this new rule.
Thank you. Appreciate it. Thank you now.
Y'all take care.